Good morning, good afternoon. I am Marco Buscema. I'm an Italian lawyer. I am the proud founder of Will. And as on Thursdays, we have our amazing The World of Law sessions. Today, we are proud for having a speaker, attorney Erwin Roelofs from Amsterdam. Erwin is a seasoned lawyer. He is a polyglot who speaks, of course, Dutch, English, and German. He's expert in corporate law and M&A, and he is also in the Will Benelux group. And in the grand presentation of this group, we'll know more about his role. So thank you, Erwin, for sharing the presentation today. There is something very specific, and it's in the title of your presentation today. So I don't want to consume too much time of yours. So the stage is yours. Then we'll interact with you later. Thank you, Erwin.
Yeah, thank you so much Marco for your introduction. I hope you can hear me properly and that you can also see the presentation now, and you can also see my video, my camera's on. So, yeah, thanks for being able to tell you something about the things that are most interesting for me, at least, and that's in this case law of the Court of Justice of the European Union regarding international company law. So let me first show you the table of contents for the next 15 to 20 minutes. So we'll first give a short introduction about myself in addition to what Marco already did. Then we will start talking about European company law, EU company law, basically. Then I will shift to private international law in the European Union, mostly focused on corporations, on companies. And then I will give you the basic rules of case law of the Court of Justice of the European Union as given during the last 4 decades. And I will focus on the last case, which was given in April of this year. And this also concerns an Italian case. And I know many Italians are on the call right now, so it's even more interesting for you. Although it might be company law and not, for example, criminal law of one of your other expertises. So, short introduction in addition to what Marco already did. Many thanks for that, Marco. I'm Erwin Roelofs. I'm a Dutch lawyer. I studied notarial law and tax law, both finished in 2006. I studied in Utrecht at the University of Utrecht in the Netherlands. And at the same university, I also did my PhD on cross-border division of companies with limited liability. At the moment, I'm an advisor. I have my own firm, CRPC Legal BV, and I'm also an assistant professor at the Utrecht University. So I work together with Koen Gijsbrechts and other members of the Benelux team, of course, in the Will Association, and I'm a member of Will since August of this year, after having been given the opportunity to attend the wonderful conference in Amsterdam in June, which was really nice, and then I decided to join your group. So, and I'm really enjoying it, and I think there are lots of chances to cooperate on many topics. So let me go to the details of European company law. So what we see is that if we look to European company law, it has heavily influenced the national company laws of the several member states. And the EU used various instruments for that purpose. So there are a couple of directives, on EU level. So they're based and focused on, for example, capital protection and minimum capital requirements. Directive focused on formation of companies. A directive focused on annual accounts, on takeover bids, on corporate sustainability. We have the recent Corporate Sustainability Reporting Directive and the Corporate Sustainability Due Diligence Directive, CSDDD. So those are all directives that are very important for the national legislations of the member states, because all those directives have been or have to be transposed into national legislation. So, and when we specifically talk about company law, we also have one important directive, and that directive focuses on national and cross-border merger and national and cross-border division, as well as cross-border conversion. So we also have regulations at the level of the European Union, for example, the SE regulation and the SCE regulation, on the basis of which it's possible to incorporate supranational legal forms like the European company law, European company, and the European cooperative society. So, but one of the most important bases of EU company law, in my opinion, is the Treaty on the Functioning of the European Union, also referred to as the EU Treaty. So, and the EU Treaty contains the freedom of establishment for companies and for individuals, and I will tell you some more about that on the next slide. So, and the fourth, also very important, pillar of EU company law is case law in cases of the Court of Justice of the European Union, and that's all based on preliminary questions of the national courts of the member states, and they are all about the compatibility of national laws with EU law. And all those questions actually concern questions national legislation is in accordance with the EU Treaty, mainly with the freedom of establishment. So let me quickly show you the text of the freedom of establishment. So then we have to go to Article 49 of the Treaty on the Functioning of the European Union. And based on that article, the freedom of establishment has a very wide scope. And as you can see, on the basis of this article, restrictions on the freedom of establishment of nationals, individuals, natural persons of a member state in the territory of another member state shall be prohibited. And it's also good to know that such prohibition shall also apply to restrictions on setting up of agencies, branches, or subsidiaries by nationals of any member state established in the territory of another member state. So, and the freedom of establishment also include the right to set up and manage undertakings, in particular companies or firms within the meaning of the aforementioned paragraph. And the paragraph I will talk about on the next slide, which is also Article 54, because the freedom of establishment is laid down in Article 49, and the scope of the freedom of establishment is widened in Article 45, because Article 45 talks about companies. So, and companies in the meaning of the EU Treaty are companies or firms formed in accordance with the law of a member state and having their registered office, central administration, or principal place of business in the European Union. And all those companies are, for the purposes of the EU Treaty, treated in the same way as natural persons who are nationals of a member state of the European Union. So, and the freedom of establishment and this article have a very wide scope, because it means that companies fall within the scope of the freedom of establishment, but also firms constituted under civil or commercial law, also including cooperative societies and other legal persons governed by public or private law, save for those which are not profit-making. So basically, it's not only applicable to companies with limited liability, but also to associations, to foundations, to cooperatives, etc. So then the third topic, private international law in the European Union, because all those topics have a certain interference with each other. So that's why I have to talk about international private law at the moment. So there are basically two systems of private international law, and maybe you're familiar with that. So in the first place, we have the incorporation theory. And according to the incorporation theory, the applicable law to a company will be determined in accordance with the location of the official seat or the statutory seat of a company. So the seat, as mentioned in the incorporation documents or the articles of association, is the connecting factor to determine the law applicable to a company. So on the other hand, we have the incorporation theory, and on the other hand, we have the real seat theory, and in that case, the location of the head office or central administration or principal place of management is the connecting factor to determine the law applicable to a company. So let me give you an example. For example, we have a Dutch company. And it's good to know that the Netherlands apply the incorporation theory. So in the Netherlands, we only look at the seat as mentioned in the article of association to determine the applicable law to a company. So we have a Dutch BV, and the Dutch BV transfers its head office or real seat or place of central administration, however you will call it, to Luxembourg. Luxembourg applies the real seat theory. So Luxembourg sees a company with its real seat in Luxembourg, and from a Luxembourg perspective, the Luxembourg lawyers may argue that this company is a Luxembourg law-governed company because it has its real seat in Luxembourg. And then we come to the strange situation that such a company is, from a Dutch perspective, only governed by the laws of the Netherlands, whereas from a Luxembourg perspective, the company is governed by the laws of Luxembourg. So basically, this is a company with a dual nationality. And in the past, such companies with a dual nationality have been created quite a lot to actually benefit from legal systems like the Dutch system, and also benefit from tax systems like the tax system in Luxembourg. So that's good to know, and we'll now shift to case law of the Court of Justice of the European Union. And as mentioned in the introduction, we have almost 4 decades of case law related to European company law. Unfortunately, I don't have the time to talk about all this case law because that would take me 20 hours instead of 20 minutes. So I summarized the basic rules of case law of the Court of Justice of the European Union as far as it relates to European company law. So the first rule is that the incorporation theory and the real seat theory, as just explained, are equal and are both allowed under the EU treaty. So the EU laws don't have any preference for one of those two systems. So Luxembourg law can still apply the real seat theory, and the Netherlands can, for example, still apply the incorporation theory. And I think this situation will continue to exist during the coming decades. Second basic rule is that member states may not apply their own rules to companies governed by the laws of another member state. So if you go back to the previous slide, our example, the Dutch company that transferred its real seat to Luxembourg, and that company is treated as a Luxembourg company because the real seat of the company is in Luxembourg, is actually in contradiction with European law, because European company law and also the freedom of establishment also entails the recognition of a company governed by the laws of another EU member state. So this, based on the second rule, actually, companies with dual nationality are not possible anymore. They still exist, but actually it's not really in line with EU law as it currently stands. The third rule is that the freedom of establishment does not give the right to transfer the seat while remaining being subject to the law of incorporation. For example, if we go back to our example of the previous slide, but we do it the other way around. For example, the Luxembourg company wants to transfer its real seat to the Netherlands. Then Luxembourg law says, well, that company does not comply with our rules anymore. So the company will be dissolved by operation of law. So that rule is fully in line with EU company law because companies don't have the right to transfer the seat while remaining being subject to the law of incorporation based on the freedom of establishment. Fourth rule, that's a kind of variation on the third rule, is that the freedom of establishment entails the right to transfer the seat to another member state if and when the law applicable to a company changes. So, for example, a company may transfer its seat and may at the same time cross-border convert itself into a company governed by the laws of another member state. So the EU laws, especially the freedom of establishment, gives companies the right to transfer the seat in combination with a cross-border conversion. As a consequence whereof, the legal form changes and the applicable law to a company changes. Fifth rule, and that's actually the last rule for now, is that if a member state and if the laws of a member state contain certain rules for a certain restructuring, for example, like a merger or division or conversion, then these rules also apply in a cross-border situation. So a company that's allowed to effectuate a legal merger under national law, then that's also possible in a cross-border situation. Otherwise, that would entail a discrimination of that company. And also, when effectuating a cross-border conversion, then this does not require an economic activity in another member state. So we have quite some flexibility in the EU company law to do restructurings within the European Union, like a cross-border merger, like a cross-border division, and a cross-border conversion. So let me go to recent case law of the Court of Justice of the EU, because during the last couple of minutes I tried to summarize 35 years of case law. It's especially interesting to focus on the most recent case law of the court. And it's a case of the 25th of April 2024, also referred to as the Edelwerk 2 case. So let me first show you the facts of this case. We have an Italian company, and forgive me if I don't pronounce the name not correctly. It's Agricola Torcrescenza SRL. It's an Italian company, and the only asset of that company is a castle close to Rome. And the main activity is also to manage that castle. So that's the case, that's the starting point. At a certain moment, the Italian company was cross-border converted into a Luxembourg company, SDE SARL. And that company continued to own the castle close to Rome and continued to manage this castle. So far, so good. Then a proxy holder was appointed at the level of this company SDE SRL in accordance with the laws of Luxembourg. So the company is now governed by the laws of Luxembourg, and if we're going to comply with certain rules, then we have to go and to look at the laws of Luxembourg, of course, and not to the laws of Italy anymore. At least that's my opinion. The proxy holder was appointed, and subsequently the proxy holder sold and transferred the castle to another company, Edelwerk 2 SRL, on behalf of the Luxembourg company. Then SDE SRL started legal proceedings against Edelwerk 2 to actually nullify the transaction for reasons of that the appointment of the proxy holder was contrary to the laws of Italy. And now, yeah, you can think, well, the company was cross-border converted into a company governed by the laws of Luxembourg. So why should we look to the laws of Italy? Well, then we have to dive into Italian law a bit. So, and here I copy-paste the title of the Italian law that's applicable to this case. And based on this Article 25 of a law of 1995, companies and associations shall be governed by the laws of the state in whose territory the corresponding formation procedure was completed. And, however, Italian law shall also apply if the seat of administration is located in Italy or if the principal object of such entity is located in Italy. So, based on this rule, you could argue that even that the company is cross-border converted into a Luxembourg company, Italian law is still applicable because this company had its principal object, his main asset in Italy, and its activities, being the management of the castle, was also in Italy. So the highest court in Italy asked a preliminary question to the Court of Justice of the European Union whether this Italian rule is in contradiction with the freedom of establishment. So, for your convenience, I pasted the preliminary question on this slide. It's very difficult to understand, and even after reading this numerous times, I still have lots of questions about the interpretation. But basically, it boils down to the question whether this rule of international private law is in line or in contradiction with the freedom of establishment. So then the Court of Justice of the European Union considered the following. First of all, it considered that EU law and the freedom of establishment, as laid down in the EU Treaty, are applicable in this case. Furthermore, the court also considered that this rule of Italian law imposed a barrier in exercising the freedom of establishment, because this company, if Italian law would also be applicable, this company had to comply with both Luxembourg law and Italian law. So in terms of compliance, you should do a lot of work. Court also considered that in this case there were no justifications to impose such a barrier because this rule of Italian law imposed a general barrier, irrespective whether the interests of stakeholders were jeopardized or not. So basically the court concluded that this rule of Italian law and about the applicability of Italian law was in contradiction to the freedom of establishment and should not be applied anymore in EU situations. However, this rule can still be applied in non-EU situations. So, for example, if the Italian company was moved to another non-EU member state, this rule would still be applicable and that would still be good because the freedom of establishment and EU treaty are not applicable in such situations. So the sale and transfer of the castle was fully legally, and yeah, the conclusion is that the company lost the castle. That's a pity because that's not what they wanted to do actually. But we can be happy because Italy has, when we go back from the legal system and we go to the real estate itself, real estate cannot be moved. There's a lot of beautiful real estate in Italy, and then we can say what is in Italy stays in Italy, at least as it concerns real estate. So that was basically it. Thank you for your attention. Thank you for being available to hear this short presentation on this very interesting topic. I hope you have any questions. If you have them, please ask them.
Thank you very much, Erwin. It was really, really informative. And that's the exact message. I'm a lawyer, but it's a completely different domain of mine. And but I feel confident. So I feel confident in international trade. If they ask me something, I'm not forced to get a license in the Netherlands. I'm not forced to get a knowledge to get a knowledge on a specific topic because I will cooperate with colleagues like you. But so it's very important. So my understanding of your presentation was of course I listened to you, so it was my understanding was general, but still there are many details I I would need to go deeper to. So, okay, we have some minutes left for the people here. Ciao Kalyani from Mumbai. You joined the session some minutes ago. If you, well, it's also your domain, Kalyani. So in general, so you can add something from the point of view of India or Maharashtra or Mumbai, which is a very big business center. So introduce yourself, Kalyani, and then if you have something for Erwin to interact with, please.
Hello, everyone. Good evening from Mumbai. I am Kalyani Sharma. I am a corporate lawyer and I am a partner in Singhania and Company LLP, which is a full-service law firm based out of Mumbai, India. And my core specialization is corporate and commercial transactions, as well as mergers and acquisitions. And it was very interesting I could hear only the end part of the case law or
you left the
whatever.
recording. You left the recording.
Yeah, whatever Erwin was explaining. So it was quite interesting for me because it's a topic which I would like to understand more in future. Maybe overlook the recording and then come back to Erwin maybe later, or do a one-to-one with Erwin to understand more.
Yeah, you're more than welcome. It's a very interesting topic, and the main benefit is that it's European company law. So if you dive into it, you have the European company law of 27 member states. So it's quite an area in the world. And of course, if you have any questions, always happy to help, happy to assist. For the corporate aspects, also many tax aspects to be taken into consideration. But of course, then we also have colleagues in our network that are happy to assist, at least in the Netherlands. Gunnar, who is also on this call, he knows all the things about the tax aspects of these kinds of transactions.
Yeah, thanks, Erwin. Thanks for your presentation. Very informative. Yeah, a lot of different I think similarities between the topic we just spoke about and the tax aspects of moving companies or mergers or demergers cross-border. Yeah, so if anybody would like to or has an actual case, like to know and understand what kind of aspects are these global mobility of companies, then yeah, please feel free to reach out to us.
Yeah, Gunnar.
Gunnar, sorry.
Sorry? Can you hear me?
I'm not sure that so Erwin is entitled to interact with you, or I'm not sure I got the entire remark of yours.
Okay, yeah. Sorry, guys, I'm in the car, so
no problem. No problem. Okay, great. So we have Paola Turello with a question.
Other questions.
Yes, I have a very interesting case. It runs since 20 years, the case in Italy. It's about indemnified by reiteration of expropriation constraint. And we will have the cassation court decision probably at the end of this year. And then if the clients that at the beginning there were 40 clients, now they remain 30 or 25, they decide to go to Court of Justice for the violation of freedom of property. We will go. And can I ask if you do this kind of cases in the European Court?
Oh, I don't do that because I'm not allowed to do that. I'm an advisor, but I cannot proceed in court in the European Court of Justice. So that you need a special license to do that. Of course, I know people that are allowed to do that in front of the European Court of Justice. So only a few, but I'm happy to help you with finding the real person.
Thank you very much. Appreciate.
Of course, of course.
Great. Okay. Other remarks, questions? I don't know, something from, again, it's not my domain, so I could say something inconsistent, but we have two criminal lawyers here. So something, could something be related also to criminal law, speaking about what Erwin shared with us today? Maybe Claudio or Paula would like to add something, or your point of view.
Thank you, Marco. In fact, I was wondering about what the financial police could have said about this transaction, because in Italy we have the problem of what we call in Italian is esterovestizione. I don't know how to translate it into English, but it's the case when a company is only formally established outside, but the main object of its business is taken out in another in Italy. I mean, I have my base in Luxembourg, but I work only in Italy, and often we have problem with tax-related crimes. And I believe that this case could be one of the remarkable one for what we can say a fake establishment of the company base outside Italy, just not to pay fully the taxation we have in Italy. And so this could be a problem for the tax criminal law.
Yeah, true. I'm not a tax lawyer, so then we have to look at Gunnar again. But what we've seen that you're basically talking about artificial transactions just effectuate.
Let's say, Erwin, I just got a help prompt for my tools. Esterovestizione could be translated in misuse of foreign residency.
So, of course, these transactions can be effectuated to misuse foreign residents. Of course, that's the case. And I think that's also the reason, basically, when the European Union legislator designed the most recent directive on cross-border merger, cross-border demerger, and cross-border conversion, that they also introduced the requirement of a certain pre-merger, pre-demerger, or pre-conversion certificate, pursuant to which a certain authority in a member state has to certify that the restructuring is not focused on misuse of law or fraus legis or criminal activities, etc. So that's actually something that was introduced by the EU legislator to avoid these kind of artificial transactions you're talking about. But of course, it cannot be excluded.
I think on the sideline, Erwin, there's also discussion about economic substance in different jurisdictions and anti-abuse legislation for corporate and withholding tax law. So I think it's a combination between the topic you just spoke about and things like BEPS and EU directives on general anti-abuse regulations for having a different place of management instead of your residence of the company.
True. Thanks for that.
Okay, so
Any
great
other questions.
maybe room for the last remark or last question. Otherwise, I will ask you, Erwin, to briefly, a couple of minutes, recap your fantastic presentation, recorded, so we are able to share it later and also to put it on the YouTube channel, Will's YouTube channel. And so if you want to recap a couple of minutes, Erwin.
Yeah, sure. Can I already start with that, Marco?
Excuse me?
Can I
Erwin?
already start, Marco? Because
Yeah,
I
you
didn't
go.
hear you.
Okay, so you can
Okay.
go. 2 minutes.
So, okay, thank you. Thank you. I just gave a presentation about EU company law for Worldwide Independent Lawyers League. It concerned basically the basic rules of European company law and how national laws of the member states are influenced by European company law. So we focused on the several pillars of European company law, being directives, regulations, the case law of the Court of Justice, and of course, last but not least, the EU Treaty. So we also paid attention to the various systems of private international law, the incorporation theory, and the real estate theory. And last but not least, we summarized the 5 basic rules of the case laws of the European Union Courts of Justice. And finally, actually the reason to hold this presentation, we paid attention to recent case law of April of this year, 2024, about the transfer of seats and the cross-border conversion and the applicability of Italian law to a company that was cross-border converted into Luxembourg law. Thank you very much for this, and I hope you will enjoy the presentation.
Definitely yes, Erwin. The answer is already yes, and I will be happy to share the recording later on this afternoon. So thank you very much. Thank you, Paolo Aturello from Udine, Italy. Thank you, Erwin Roelofs from the Netherlands, Claudio Natali from Modena, Italy, Kalyani Sharma from Mumbai, India, and thanks to Gunnar Gisbrecht, tax lawyer from Amsterdam and affiliate in Will Benelux and in the tax law group. Thank you very much, and thank you for referring Erwin to Will. Thank you, Gunnar, for this. Thank you very much, and enjoy the rest of your day. Thank you, thank you, thank you. Our motto in the Global Convention in Warsaw. Thank you very much.
Thank you. Bye-bye.